Welcome to Court Cam HQ, where courtroom reality hits hard. In today's explosive footage, watch as Judge Raquel West deals with 3 cases which are very interesting to say the least. 1. Witness a jaw-dropping moment as Katherine Welch stands before Judge Raquel West with an almost unbelievable record. 10 prior DUI convictions. After multiple prison sentences and countless second chances, she tearfully begs the court for mercy one more time. 2. Judge West completely loses patience with a defiant defendant who refuses to accept responsibility for her actions. After kicking a police officer during a routine traffic stop, this woman stands before the court still making excuses. And 3. Judge West delivers the ultimate wake-up call to 2 young defendants who thought jail was just a game. Stay tuned for some of the most powerful examples of actions have consequences you'll ever witness in a courtroom.
All right, this is cause number 24, DCCR 0122, State of Texas versus Katherine Welch. Ma'am, are you Katherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Malfino has already stated, as well as I have received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Malfino, you've had time to review it as well?
Same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well?
Yes, Judge.
I did.
Okay. Is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talked about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything. Or
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No, Your Honor.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking for. I have sort of personally taken Katherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity to be here in front of you asking what we're asking for? She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report if she felt she needed treatment, she said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Katherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position that we're asking the court to take here. Obviously, if the court would like her to address the court, she is happy to do that, or I'm not sure how you want to proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Burks. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that are on the roads every day to stand up and say I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she could continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information that you have before you.
All right, thank you. Anything else?
Would you like to say something, Judge?
Your Honor, I just want to say that the past was fueled by drugs and alcohol. I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain, just numb myself out. I didn't know how else to deal with that. And when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility in Oxford House in Spring, and I worked there until I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right out of a year. And I'm sorry, I'm very nervous today, and I know that my past record is like Ryan said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some really good choices with my Mid-County AA friends. They've helped me a lot. And I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you. So, Ms. Welch, Ms. Malfino probably said it yet best, and I get this often, and they don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, it's several things, and it's to look at, obviously defendants and giving chances and things like that, but it also is about making our community safe. And I have to look back. This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to Safe P 3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 year back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one. So they give you 15 years and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand, to some extent, addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our roads again. And so, good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned.
1 million, zillion, jillion, dillion, cotillion times later.
So, was there another one and then this was an updated one?
No, because I thought this should be
Like
talking.
this says this is an update. So, is there an old PSI?
This is the old PSI that's in there. There isn't an updated one. She said the only update is this cover page.
Reflected on the cover page.
Right. So I don't know what that means. The only change reflected is the cover page.
They didn't do it updated. Because I spoke with Miss Johnny and she said this is the same one from the last PSI. The old one is.
Here's both of them.
I guess I don't understand why we got two. I'm very confused.
Well, this was
Remind me.
where she had pled when you refused to go along with it because she didn't accept responsibility for the crime.
Uh-huh.
And then we came back and she did accept responsibility, so we re-pled for the same.
Okay.
There was a different attorney involved on the first time and then I was appointed.
Yeah, she pled in May of last year. Was full deferred with Tom or back.
So nothing else was done as far as them talking to Miss Johnny about
No.
acceptance of responsibility. They
I
didn't.
think Miss Johnny said they called and asked her for her updated address and that was it.
Okay. So, Miss Johnny, I'm going to ask you again, and I know we probably went through this before. First of all, you're Kirsten Johnny. And Miss Johnny, I want to make sure, because in that previously you said you didn't do it, you were forced to do it because of your financial, you were forced to plea because of your financial situation, that it wasn't fair. And so tell me what your position is now.
I never really said I didn't do it. I said it was an accident.
Okay.
I still feel the same way a little bit.
All right.
I'm not even gonna say I do feel the same way.
Now I understand, but you're not disagreeing that you didn't.
I said it was an accident. Somebody grabbing you by your foot. That's like somebody accident hit you in the back of your head. You're gonna have something that's normal.
Well, right, because you were not complying with what they told you to do to get out of the car, correct?
I was pulled over because I was in a high. I stay in the area. I was pulled over because.
Hang on. Don't talk yourself out of this again. Because if you want to talk yourself out of it, we'll put it on the trial docket and we'll get it done in a few weeks and let a jury decide. Look at me. I'm actually trying to help you right now. Okay? If you had complied and just done what he asked you to from the very beginning of that stop, none of this would have happened. Do you agree or disagree with that?
Yeah.
Yes, what?
Yeah.
No, do you agree? Listen to the question. Do you agree with that statement or do you disagree with that statement?
I don't want to lie.
You don't like it, do you? You don't think he should have done that?
It's not that. I feel like we was pulled over for no reason. If you follow.
It doesn't matter if you were pulled over for no, listen to me. This is why we're hearing stuff all over in the news. It doesn't matter what you think. If a cop pulls you over, then you take the ticket for not wearing your seatbelt. This is all over not wearing your seatbelt. And here you are in felony court and you're still not taking responsibility for the fact that he said, hey, ma'am, do this. And you said, I don't think you should have pulled me over. So I'm going to do whatever I want to do. And I'm going to lodge my foot against the door and I'm not going to get out. I'm going to make you drag me out of my car and then I'm going to kick you because you shouldn't have pulled me over in the first place. When all you had to do was get your ticket, go to JP court and try to fight it there legally. But here you are in felony court for a second-degree felony instead. So do you want to try to tell that story to a jury, or do you want to accept some responsibility today?
I don't feel like going to trial.
You don't feel like going to trial. Well, there's two parts to that question. Do you feel like accepting responsibility? Do you think it would be a better idea next time you're pulled over to comply and just do what they ask you to?
Yes.
And Your Honor, just for the record, Miss Johnny did review the video with me in my office, so she is aware of what all transpired. She saw it.
Do you have any reason to believe she shouldn't be pleading to this from what you saw?
I do not.
So, I mean, you even saw how you acted. It's probably a good idea. All right. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I hope you prove me wrong on this, because I really have some concerns that you're going to be able to be successful, because you're not taking responsibility and you're not wanting to follow directions and things like that. And you're about to have 4 years of having to follow directions on probation. So I'm going to defer all proceedings for 4 years. You're ordered to pay a $500 fine. You're ordered to follow all of the rules and conditions of probation. If you do that, this is a great opportunity today, because you are not a convicted felon. You don't have that conviction on your record. And if you successfully complete it, follow all of the rules, you will never have a felony conviction. At the end of your probation, the case will actually be dismissed. The other side to that, though, and this is really important for you to understand, because we've had this conversation now so many times, I'm not likely to forget you. And you can ask anybody, and Ms. Holmes has known me for a long time. It's not usually good when I remember people, right? So if you violate your probation, you'll get brought back into court. You could be found guilty, which means you become a convicted felon, and I can sentence you to prison anywhere in the range of punishment, which is up to 20 years in prison for this. You understand?
Yeah.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will go over your paperwork as soon as they're ready.
Okay, and you said that I'm not considered a conviction felon, but I was told that even though you say that, it's still going to be on my record.
So the arrest is on your record. The arrest will always be on your record. But so if you're asked a question on filling out an application for a job or something, if it says, have you been convicted of a felony? The answer is no. But if it says, have you ever been charged with a felony, or are you on probation for a felony? You are going to have to say yes to that. But the conviction part is still better than nothing, not having that conviction, right?
Yes.
Okay, have a seat in the courtroom. Watch for probation to call you up.
2,000 years later.
Mr. Kimler, you have Corey Carter. I thought this was set for a plea.
Well, it was, so they would prove the offer.
Give the court explanation, Your Honor.
It was gonna.
Judge, we discussed what I thought was gonna be a solid agreement, and then after reviewing jail disciplinary, I just didn't think the court would approve it. So, I upped my offer, which is being refused.
Yeah, just to be clear, Your Honor, I had gotten Mr. Nichols to extend an offer of 4 years, which Mr. Carter was prepared to accept, and that's when I set it on the docket today to plea. I was contacted by Mr. Nichols yesterday and advised that he was withdrawing that offer based upon the jail write-ups, which I've been provided with, and that the offer was now 6 years and with a 7-year cap, and Mr. Carter previously refused 5 years, so I did another refusal.
So, Mr. Carter, how old are you?
17.
17 years old. And do you realize now what you acting up in jail has already cost you? Do you really? Tell me what it's cost you. Well, some of your life. But you had already talked about a deal in your case that sounds like you were going to accept. Is that right? And because you can't behave and follow the rules in jail, and I get those reports, and the district attorney's office gets those reports, and your attorney gets those reports, they decided you don't deserve that, and I don't disagree with them. So here's what happens now. If your case goes to trial, and I'm going to go through some things in a few minutes about that, and you get found guilty in that trial, that jury can also hear all of those reports, every last one of them. And if you think this man right here ain't going to bring those in and show that jury why you don't deserve any mercy or whatever, he's going to do it. I would if I were him. So if you're going to be in front of a jury, or you're going to be in front of the judge, or someone who's deciding what happens to your life, you might ought to change what you're doing in that jail. I just had a talk with another young one. I don't know what's going on in that dorm with all of you young ones, but what y'all all need to do is look at each other and say, I don't want to go to prison for a long time. If you do, you go act up over there. And man up and say, I'm not going to behave like that. Because you're a man now. And you're in felony court. You don't feel like a man. Your brain's probably not functioning like a man. But you are in felony court like every other grown-up man. And if you make kid decisions and think that horseplaying and treating the people that are trying to work there the way you are is going to get you anywhere, it will. It's going to get you in there longer. Does that make sense? So what you're charged with is the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And what that means...
Judge, I'm sorry to interrupt again.
Yes.
He has a juvenile adjudication, which he is actually on parole for.
Felony conviction.
And it's a felony conviction. My understanding, and I need to file the proper notice, my understanding is that can be used to enhance him to a second degree. I don't think it precludes him from maybe getting probation from a jury. I need to make sure I vet that out through the family code.
Okay.
But my understanding is he's looking at a possible second-degree punishment range.
Do you agree with that?
It's a hybrid situation with the prior juvenile felony conviction. I think that Mr. Nichols is correct that it precludes, or it does not preclude him from having to be eligible for probation from a jury. However, it will enhance the punishment range from a third degree to a second degree.
So, Mr. Carter, what that means is that if you go to trial and a jury finds you guilty, and they find that that previous adjudication took place and was true, that you were adjudicated as a juvenile of a felony, that means that jury can sentence you anywhere in the range of punishment of a second-degree felony instead of a third, which is between 2 years and up to 20 years in prison. Do you understand? And I have a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison or for a 7-year cap to me. You have every right to reject that offer and have your case set for trial. We've talked about all that. Do you want to reject that offer and have a jury decide? Okay, then we'll get your case set on the trial docket as quickly as we can. Again, don't get over there and forget what I told you today. It's very important. Do you understand? Okay, go back with the bailiff.
Thank you.
Many, many minutes later.
Good morning. Are you Camden Jackson? And Mr. Jackson, in cause number 25 DCCR 0114, you're charged with engaging in organized criminal activity. Ms. Perazo has filed a motion to withdraw as your attorney. And so do you have any opposition to me allowing her to withdraw? Answer out loud. Okay. So Ms. Perazo, I will grant your motion. Mr. Jackson, do you have the funds to hire an attorney?
Working on it.
You're working on it? So here's what I'm going to do in the meantime because you're in custody. I'm going to go ahead and appoint an attorney. That way you have no lull in representation. Somebody will begin working on your case. If you get someone hired, then they can file the appropriate motions to step in, okay? But you will be appointed an attorney today. Now, before I send you back to the jail, I want to talk to you about this stack of incident reports that I have of how you're behaving in our jail. And I know that one of the things that you wanted Ms. Perazo to do and that she had filed on your behalf that we're not going to take up today is for me to reduce your bond. And I can assure you nothing's going to happen other than your bond being increased if you continue to act like the little hooligan that you're acting like in our jail. I can't even tell you how angry this makes me. How old are you?
Just turned 19.
Just turned 19. Well, let me tell you something. It is time to grow up. Because you and the other little 18, 19, whatever y'all are doing in there, you're never going to get out of jail. You're going to end up in prison, and your life is just going to be just like this. And is that what you want?
No, no.
It's not, is it? Cussing at the correctional officers, laying in bed because you don't want to get up, staying up late because you don't, you know when you get to sleep late? When you're at home because you're not in jail for violating the law. That's when you get to sleep late. That's when you get to make your own decisions. You don't get to make those decisions right now. And I get a report every single time you're acting up. And you're going to keep coming in front of me with another lawyer, and it's the same thing. The DA knows about these, and if you think that's going to make them want to be nice and offer you some great deal on your case, it's not. All it's going to make everybody want to do is something worse to you. So starting today, if you think you want something good to come out of your case and you want some possible good treatment and to get out and to be able to live a life like the rest of us, start proving it starting today in jail. Otherwise, it's not going to happen. Do you understand? All right, go back with the bailiff.
Thank you, Your Honor.
Thank you.
And there you have it, folks. You've just witnessed Judge Raquel West's unwavering commitment to justice and accountability. From the repeat DUI offender facing the consequences of her decade-long dangerous choices, to the defiant officer kicker learning respect the hard way, to those two young inmates discovering jail isn't a playground. Each defendant faced the reality that actions truly have consequences. If these powerful courtroom moments resonated with you, smash that like button and join the Court Cam HQ family by subscribing now. Drop your thoughts on Judge West's handling of these cases in the comments below. Hit that notification bell to never miss our daily dose of raw courtroom drama, where justice is served without filter. This is Court Cam HQ, bringing you the moments that prove the courtroom is where excuses come to die.